Hi, I'm Chris Morgan. Meeting the cost of nursing care is a challenge for any family. What can be harder is knowing what programs are available to help with the cost and what the requirements are to take advantage of them. At Morgan Law, we help our clients plan for nursing or other long-term care. Most of our clients are concerned about losing their home to the state. There are some really pervasive myths, both about what the state will do if you need nursing care and myths about what you can do to stop the state from taking your home. In general, the state of Utah will only pay for nursing care if a person is medically needy to the point that they are unable to perform some essential tasks of daily living. Tasks like feeding themselves, toileting themselves, clothing themselves, bathing themselves, and moving around freely. The state pays for nursing care through its Medicaid program. This is essentially state-funded medical insurance for those without resources. This is different from Medicare, which is a federal government insurance program for those who are over the age of 65. Medicaid will pay for nursing care. Medicare will generally not pay for long-term care. So, if you want the state to pay for nursing care, you have to be on Medicaid, which means that you have few, if any, assets. Generally, Medicaid requires that a person has less than around $2,000 before they can be accepted onto Medicaid for nursing care. There are some exceptions to this rule. For example, a home, household furnishings, some personal belongings, and one vehicle are generally exempt when they're calculating a person's assets. However, when a Medicaid recipient dies, the state is authorized to put a lien on those remaining assets to pay back the cost that the state spent on nursing care. One major myth says if you just give away all your assets, the state has to cover you. I could share some real horror stories where parents just gave their home to their children in order to keep the state from taking it, only to be then denied Medicaid coverage. The law gives the state a 5-year look-back period, meaning that the state will require a 5-year financial history from whoever is seeking assistance with nursing care. If the state finds an instance within the past 5 years where the applicant gave away a valuable asset, the state will impose a penalty period, during which the applicant will not be able to qualify for Medicaid. Here's where a trust can be helpful in some cases, but not all. In a Medicaid Asset Protection Trust, a person gifts their assets into a trust, managed by another trusted loved one. The trust becomes the owner of the asset and holds it for the benefit of the person's descendants. If the transfer is made at least 5 years before the person requires nursing care, the transfer is not reviewable by the state. One major myth is that any trust works. The rules here are super specific. Most trusts, especially your standard revocable or living trust, will not do any good when it comes to qualifying for state nursing assistance. At Morgan Law, we know the Medicaid rules and we can help set up those specialized trusts. Trusts are just one way to meet the needs of a client. Nursing care requires creativity. At Morgan Law, we can get creative to create a plan that works for you and your loved ones. We know you're going through a difficult situation right now. This is not a time to deal with pushy people. We aren't here to push. We're here to be helpful and help you work through that difficult situation. Give us a call.